Good evening. I really appreciated this continued forum of discussion. And on that note, the theme of this is looking at human rights, lesbian and gay human rights, with decriminalizing restrict religious freedom. I have yet to hear true acknowledgement about what is happening worldwide. What was stated before and asked in regards to the rapid rate at which you see a change in legislation, and again, precedents from decriminalizing to legalization of civil relationships and so forth. So, and you are seeing cases consistently, not just in public domains, where Christians, for instance, you have the Christian Legal Society in California. A group of students cannot be recognized in a school because their religious faith statement to become a member is contradictory to the anti-discriminatory law. You also have cases where Christians cannot adopt because they do not agree that homosexuality, based on their belief, is correct. You have Christian adoption agencies being closed because they do not agree to same-sex couples and so forth. So this is a reality. I haven't heard about this widespread reality. And the reason I'm saying this is because I'm asking you that idea of restrict religious freedom. You're saying, to me, two rights are vying for supremacy, and I'm asking you, how can we find a balance? The right in regards to persons who are in the LGBT community to not feel hated and violated, and yet at the same time, and I feel as a part of the Christian thinking community, my rights are somehow being dismissed or undermined because we are saying one right is supreme. So could you respond to that? These two fundamental rights, how do we get that balance?
Okay,
because restriction is occurring.
Yes, very good question. Yes, very good question. Because there is some concern that the recent court decisions by the UK and the European Court of Human Rights suggest that somehow sexual orientation is supreme over religion. And that is not, I would argue that's not the case. What you have to look at the specific legal issue in each case. What happened in the Liddell case was that the local government was trying to promote to prohibit direct discrimination based on sexual orientation, rule that all couples would be served equally. And the accommodation Ms. Liddell asked for was to avoid indirect discrimination based on religion. So you had a basically a stronger claim competing with hers, but the situation could easily have been reversed. And that was stressed by the UK Supreme Court when they decided against the owners of Christian owners of a hotel, that if a lesbian or gay hotel owner decided to exclude Christians on grounds of their religion, the decision would have been the same. So the Christian Legal Society case, I haven't had a chance to read it. All I can say is that the US Supreme Court is not particularly radical in that area, so I think they were just trying to uphold their First Amendment principles in a public university.